recording this. Just a few housekeeping things. Be pretty easy about kind of trying to keep background chatter low. So do mute your microphone, but do feel free to unmute yourself if you'd like to ask questions verbally, which is great, especially with just a few of us. That would really work well. Or you can just put it in the chat box. Most importantly, I'm not a lawyer, so none of this is legal advice. There are some serious consequences to violations of executive session law. So if you have legal questions, as I'll state later on, you can talk to your lawyer, or better yet, you can actually contact the Ethics Commission for any advice that you'd like to get something concrete from. I do have a bunch of reference material on the ODA website. I'll have the link at the end. It's under the SWCD program and the training section. I'm going to reference these reference materials throughout this, and you should go and take a look at them if you want. So I think it's really important for all directors to know executive session law, but in particular, the chair of districts and the managers, who often are the ones that are kind of watching out to make sure that the board doesn't violate any laws. But it's really important to understand that executive session violations are not like other kind of like public meeting law violations or public record law violations, where I don't want to say it's just a slap on the wrist, but it's usually just corrective action. But with executive session violations, you have an individual liability. And the Ethics Commission, which investigates any complaints, ignorance is not an excuse to them. If you participated in an executive session that violated the law, even if you weren't the chair, you were just a board member, and even if you said, hey, I don't know if this is right, if you still participated in that executive session, you open yourself up to a $1,000 fine per occurrence. And a lot of times where there's issue with executive sessions, it's like over a couple meetings, and it's $1,000 per meeting. And that's your individual liability. That doesn't get covered by the district's liability insurance. That is what you personally would owe to the Ethics Commission if you violated executive session law. So this is why I think it's really important for folks to understand. I was at a training at a district where they actually had someone, one of the lawyers from the executive session, the Ethics Commission, speak. And he clearly said that if any of the board members think at all there's an executive session violation for any reason, that is in their best interest because of this liability issue, to state publicly, so it's in the minutes, that they believe that the executive session is violating meeting law, and get up and walk out. Because by saying that in the meeting and then getting up and walking out, you don't have that liability. And that was quite interesting. So someone is on the phone. If you don't mind, if you can mute yourself unless you're going to be speaking, so we don't get any background noise, that would be great. Thank you.
How do I do that? How do I mute?
What kind of phone are you on?
Android.
Yeah, usually like there's a mute button somewhere on a cell phone, a virtual one. But
yes,
you see it?
I see it. Yeah.
Okay, great. But feel free to unmute yourself if you want to speak. And actually, I'm interested in who is this, because I don't see a name. I just see caller number 1.
Oh, okay. Chong-Ki Tan from Marion County.
Oh, okay. Great. So Marion was where I was at that meeting where the Ethics Commission lawyer came in and told the directors that if there's a violation, that they should get up and, say they believe there's a violation, get up and leave the meeting so they're not liable for that $1,000 fine. So what exactly is an executive session? So an executive session is part of a meeting, or it could be actually an entire meeting, where the meeting is closed to certain people to deliberate on certain matters. So certain people, that means that you can tell people to leave so you can discuss these sensitive matters and very particular sensitive matters. Or you can allow anyone to attend or invite anyone to attend those sessions. So I've been in executive sessions where they asked everyone to leave except the board members. That's totally fine. And I've been in other board meetings where they've gone into executive sessions to discuss certain sensitive matters and often like exempt public records, but none of the staff or have left the meeting. It was just more to have it so that if there were any public there or not to have it printed out in the minutes that went out, so about public records. And we'll talk about some of the examples. So to deliberate on certain matters. So executive session law has only a few particular cases about why you can close off a meeting to essentially everyone else, except the media, which we'll talk about, to discuss certain matters. There's only about a dozen of them, and they're very, very particular, and they are the only things that you are allowed to discuss in executive session, and nothing, you can't stray from those. So some of the most common ones for soil and water conservation districts, because there are other ones, including like collective bargaining, but as far as I know, no district has a collective bargaining agreement. The major ones is to discuss employment, to discuss discipline issues or complaints or dismissal of a board member or employee, and to do performance evaluations. And then you will find others are discussing exempt public records. For instance, on the east side of Oregon, sage grouse plans, those were added to the list by law a couple of years ago. As an exempt public record, so you can go in executive session to discuss those. Certain kind of complaints would be an exempt public record, or consulting with legal counsel. So if you're talking to your lawyer about litigation or probable litigation, and we'll discuss that a little bit later. So these are just some of the reasons, and they're very, very particular, as you can see. So how do you go into an executive session? Well, you can hold, as I said before, you can hold a meeting within a meeting, an executive session within a meeting, or you can hold one that is purely an executive session. If you're going to do one that is purely an executive session, you have to, or you know ahead of time you're going into executive session, you have to notice that like any other meeting, and the notice must cite the statutory authority for the executive session. And you have to do it very specifically. You have to cite, it's, if I remember off the top of my head, it's 268.660 subsection 2 subsection, and then it's like A through H. And each one of those different ones that I cited before, plus the ones that I didn't cite, are a different letter of the alphabet. And you literally have to cite the extremely specific statute and the reason why verbally. So if you, A is for the employment of public officials or executive officers or employees. So you'd have to say something like, in your notice, the board of directors will be going into executive session to discuss the employment of a new employee per Oregon Revised Statute 268.660, subsection 2, subsection A. Has to be very specific. That's because the public needs to know why you've gone in there. They may not be able to participate or observe the executive session, but they do have the right to know why you're going into executive session. So you can also just call it on the spur of the moment. If it's not been pre-planned, something comes up between when you put out your public notice or you get to the meeting and there's suddenly an issue where a public record needs to be looked at, or a complaint was received and you need to discuss that. They can be called during the meeting. And again, the same thing has to happen, is that the presiding officer, i.e. the chair, has to announce that very specific statutory authority before going into executive session. So you can do it pre-planned or you can do it on the spur of the moment. So the first thing is although you can tell everyone to leave the room while you discuss certain sensitive matters in executive session, the news media must be allowed to attend. And that is to ensure that if you say you're going to go into executive session to discuss the employment of a particular person, you don't suddenly start talking about whether you're going to do a performance evaluation, or you don't start talking about a project that has gone sideways. Their job is a watchdog role, and that is to ensure that you do not stray from the topic that you said you were going to discuss under that statute. So they're not allowed to disclose what you discussed unless you stray from that topic, and then they are allowed to do that. So that is why they're allowed to attend. There are a few instances where they can be barred from a meeting, and that generally is if you're in litigation with actually the news media that they represent. So that would actually, if you're talking about litigation matters. You have to keep minutes of the meeting, either sound recordings, unlike other sound recording of meetings where you have to type out the minutes and have a physical copy of the minutes. An executive session tape recording may be kept as tape and not written out and stored separately from all your other minutes. Or you can write them out. Oftentimes a board member will sit there and write out the minutes. Again, the minutes don't have to be detailed, but they do have to talk about the general substance of the conversation. And again, those minutes would be kept separate, usually under lock and key in a sealed envelope. Another caveat of executive session is if you're convening an executive session for a performance evaluation of an employee, or discipline matter for that employee, or discipline matter for a or a complaint regarding a board member, because believe it or not, sometimes there's complaints against board members, or a matter about censor. The person being discussed has the right to request it to be held in public. That is their right, that any discussion about them be held in public. So one of the things you have to do is, if you're going into executive session, and especially if it's done on the spur of the moment, you got to make sure that the person you're talking about, if it's a performance evaluation or discipline matter, that they are made aware that you would like to go in executive session, and they have to let you know that that is fine. If they say at all, it's not fine, you cannot go in executive session. Or if you can't get hold of them, or they were not informed for whatever reason, you cannot go in executive session. And I'll give you a real life example. I was at a board meeting, and at the beginning of the meeting, the chair said, I'd like to add a performance evaluation for employee X. Employee X was not at the meeting. And I said to the chair and to the whole board, I said, it is illegal for you to go in executive session, do a performance evaluation when this person is not informed, because they have the right to hold that performance evaluation in public. And very sadly, they just ignored me and did it anyway, which was disappointing. And if I had been the kind of person that would have filed a complaint, every single board member there would have gotten a $1,000 fine without a doubt, because they had violated that part of executive session law. And not only did they do it, it wasn't even out of ignorance, which is not an excuse. They would still get the fine, but it was willful neglect. There are on occasions I've seen those $1,000 fines waived in lieu of trainings and a letter of reprimand. But certainly, if it's willful neglect, you're not going to get that $1,000 fine waived. I have been, to other places where they were going to fire an employee. They wanted to go into executive session, but the employee said, no, one, I want to participate in the discussion, and two, I want everyone to hear why you're firing me, and I want to be able to rebut it in public. And that was their choice. It wasn't a comfortable meeting because it was in public, and other employees got to see it all, and a member of the public was there, but that was the law, that that person could do that. Another reason why an employee might want to, or a board member might want to have it in public, is because if they waive that right to hold it in public, they can be asked to leave the room. So if they waive that right, you can do a performance evaluation without them. You can discuss disciplinary matters without them in the room. Just because you're talking about them doesn't mean you have to have them there if they've waived that right to a public session. Any questions on this? We doing okay? I'd say nod your head, but I can't see any of you. The last thing about executive session is that you cannot, well, it's not the last word in executive session, but you may not reach a final decision in the executive session. That is because in Oregon, there are no secret ballots or secret votes for public bodies. All public bodies, every single elected official decision has to be public. So you can discuss what you might do. You know, you might be able to do like an informal straw poll, but you can't make a final decision. You must come out in a public session, have a formal motion or resolution that is formally voted on, and that every board member's vote is tallied. One of the other things I'll just say really briefly is that committees, being a governing board, because executive session talks about governing board, it doesn't talk about board of directors, governing boards. Sometimes your committees actually have all this executive session authority too. And one of the ones that often is used is the personnel committee, which is, you know, appointed by the board and therefore subject to public meeting law, including notices and being open to the public. Will want to, you know, go ahead and discuss possible employment issues. Well, you can use the employment session, reason for a session to do that. So a personnel committee could actually go in executive session too on their own, and they have to follow all these same guidelines. So there is an executive session checklist. It is in the district guidebook, which is both online on our website, but every district should have a copy in their office. And in the back in the appendix is the actual checklist. There's the Attorney General's manual. Looks like this. All your offices should have it. This is actually a wealth of information. It's what I use to answer questions all the time. It explains everything I'm talking about in detail with court cases and Attorney General opinions. And they also have some checklists in there for your executive session to keep you that you make sure you don't go afoul of the law. And then actually on our training week website, and there is reference material that I have, and I actually have copies of the reasons why you can go in executive session and the script that you should use. So I encourage you to go take a look at that. So I took a little bit of time to look through the Ethics Commission's website, where they have they actually have the investigations and final orders for executive session violations, including ones for soil and water conservation districts, because some have run afoul of the law. So these are actual ones. So one of the ones that I noticed most is actually not citing the statutory authority at all, just saying we're going into executive session because we're going to talk about John's performance evaluation. That is not actually citing the statutory authority. You actually have to cite that ORS, or not citing the proper one, saying that you are going to go into executive session to discuss performance evaluation using, I think it's C or D. And when you went in there, you actually started talking about disciplinary matters, because part of the performance evaluation was, you know, about something that happened, and you strayed and you started talking about disciplinary matters. So follow the script. Have the script. It has all the statutes there. It's like fill in the blank. So I always say do that, because that seems like a small thing. You didn't cite the ORS number. you said you went in for a performance evaluation, but you didn't cite the ORS number. Seems kind of picky, but it's the law, and people have been fined $1,000 for not citing that specific statute. Discussing topics not covered under executive session law. You know, there are very specific, and if you stray from the topics that you said, then, you know, you went in there to talk about, you know, let's see, well, performance evaluation, that's so common. Or let's say, actually, let's say a document that's exempt from public records. Maybe it was a sage-grouse plan. But then you started talking about projects, irrigation projects. You just kind of strayed from the topic, you know, because you weren't paying attention, and you started talking about irrigation districts, or maybe who you wanted to hire to do the conservation, sage-grouse conservation plan. That straying away from that topic will get you a $1,000 fine, or just going ahead and covering topics that even don't exist under executive session law. As I mentioned before, not informing the individual being discussed. That did happen to a district. I will not name that district, but that actually happened along with not citing the proper statutory authority, citing one and going onto another one, and then straying. So one district, over 2 or 3 board meetings, which totaled $3,000 in fine, did all of these and did each of them almost every time. So very important, make sure you inform the individual being discussed that they have that right to a public hearing. Salary negotiations. So believe it or not, and I didn't know this till I started reading, you can only discuss salary during the initial discussion of employment. So under the 268-660-2A, which is about considering employment, you can discuss salary in that one for its initial employment, but you can't at any other time under executive session law. So for instance, and this is where it is where I saw it was, you went under executive session law for performance evaluation, cited the right citation, right ORS number, the employee waived their right to a public session. But in that performance evaluation, they started negotiating a salary raise, and that is illegal and leads to a fine. Another one is discussing litigation or potential litigation without legal counsel present. The law is very specific about 2 things. One is that if you're going executive session to talk about potential, actual litigation, or as they say, litigation that's likely to be filed, you must do it with your legal counsel present. You can't go in executive session and cite that specific statute, well, because you say, we might get sued, we should talk about this. For one, might get sued probably doesn't cut it, because it is very specifically saying in litigation or very likely to be in litigation. Just because you have something that thinks you might go get litigation, but it's unsure, that is not illegal. And also, you can't do it without your lawyer present, or at least on the phone. You can do it with them on the phone. So if you're going to use that statute, make sure that you are under litigation or most likely to be under litigation, and your legal counsel is present either by phone or in person. Then the next one, and I actually kind of didn't know this either, that discussing a record exempt from disclosure, so say a sage-grouse plan, or a complaint, someone filed a complaint against a board member, and you just summarize it without passing it out. You do an oral, you pass on an oral complaint. That record that you are saying that is exempt, and you are going executive session because it's exempt, you actually have to provide copies of that record to the other board members. You can't talk about it without that record actually being present. So, and this is actually what led to a fine. And so in this case, what I read about is there was a complaint filed, but all the chair did was summarize the complaint and refused to show the full complaint to the rest of the board. And that was a violation of executive session law that led to a $1,000 fine. And because this, just as a, to kind of get this into you, it wasn't a $1,000 fine just for the chair. It was a $1,000 fine for all those other board members who didn't receive a copy of that record and just listened to the chair because they participated in that meeting. And finally, sometimes people still make a final decision in the executive session and don't do it officially outside of it, and that has led to fines too. Any questions at all about any of that before we move on?
Eric, this is Debbie. Are these executive session guidelines, laws also include nonprofit board discussions?
No, so this is only for government entities.
Okay.
Yeah, so, nonprofits, I'm involved with a couple nonprofits. They have a set of policies the board has passed about when to go into executive sessions, but that's their own personal preference. And usually that has to do with litigation or, sensitive personnel matters, but they get to do whatever they want for 501c3s or any kind of nonprofit for that matter.
I appreciate that's very good news. Thank you.
You're welcome. Okay, so I want to go into a little bit more detail about a couple particular issues that might come up. One is employment. So that's 192, I guess I was saying 198 or 268. So I guess I'm getting my numbers wrong. 192.660, subsection 2, subsection A, which says that you consider employment. So there are some caveats to that in the law. The caveat is that the vacancy for the position has been advertised. So if you're doing a direct appointment, you can't go in executive session for that kind of job that wasn't advertised. Also, you have to have regular hiring policies in place that the board has been adopted already in a regular board meeting. So those two things are required for you to consider employment under this advertised position, and you have to have a pre-existing procedure for hiring. For a CEO, i.e. a district manager or executive director, whatever you have, there are some additional criteria in that those hiring standards and the criteria you're going to use to evaluate applications and any other kind of policy directive have to be adopted in an open meeting in which the public has the right to comment on them. This is one of those instances, if you hear me talk about public meeting law, I said in most cases, the public has the right to attend but not participate. It's up to the district to allow public comment, except in special circumstances. And this is one of the circumstances. If you want to use this particular statute to discuss employing a CEO, a district manager, you must have allowed the public to comment on your hiring standards and criteria for selecting them. Any questions about that? That's something most districts aren't even aware of. I actually, to be honest, I wasn't aware of it until a few years ago too, until it was brought to my attention by someone else. All right, and then handling complaints. Now, I'm going to say definitely I'm not a lawyer on this, and definitely complaints are very sensitive, and complaints is something that you may want to discuss with legal counsel or the Ethics Commission. But a written complaint or a written report about a complaint is usually considered exempt from the public, an exempt document. So you can present those to the board in executive session under 2F. As I said, oral complaints or oral reports are not, or summaries are not considered a public record, but the actual report or complaint is. You can discuss that complaint with legal counsel under 2H if litigation is filed or likely to be filed. Sometimes that's true with complaints. Just because you're worried it might be filed, that's not. However, if you're going to consider the complaint and have a discussion about, what you should do about the complaint, and discuss the report and decide about any disciplinary action, that would come under 2B. So, and 2B is one that you have to talk to the subject of the complaint, who you're gonna talk about, whether it's an employee or who's had a complaint filed against them, or a board member, because they can choose the open session. So you can receive the report, you can look at it, you can talk to your lawyer about it in executive session that doesn't include that person. But if you're going to have that kind of jury meeting where you discuss what to do about it and what kind of disciplinary action you might do for concerning that person, you actually have to inform that person and allow them to have that in open session. And that is another one that I saw that there was fines for not doing that, trying to keep the person out while they talked about them, and trying to use the one about the lawyer or the one about looking at the complaint and then discussing it. So one of the things that's important is if you're receiving a complaint and you're disseminating it to the board to look at under 2F, you got to make sure you don't stray into what would be considered 2B. You don't stray into actually going, oh gosh, what should we do about this? How are you going to discipline this particular person? You can't talk about that under 2F. Is that clear? And if you're going to get a complaint filed, it's going to be about the person that you talked about without letting them know. And that does happen. And I saw that happen. All right, these are the top 5 phone calls I get that I cringe about. We want to talk about our budget and how we can afford to pay our employees. That is not a legal reason to go into executive session. Like somehow they're going, the board wants to go into executive session. They don't really want the employees to know the back and forth about whether to give them raises or not, and if we can afford to keep them, or if we're going to fire anyone. You can't do that in executive session. That is not a legal reason. And yet I actually have been asked that on a number of occasions, or some form of that. We want to talk about legal matters, whatever that might be. That makes me cringe because, again, it has to be about litigation or litigations that's likely to happen, and it has to include your lawyer. You can't just talk about legal matters in some broad sense without those other 2 reasons why. And certainly I've heard this one more than once. We need to have a talk about one of the board members. They've been behaving badly, or one of the employees. We don't want to make this a big deal, but we want to just keep it among ourselves. So we're just going to go into executive session and have a talk. That's not valid reason to go into executive session. It goes along with this next one is, gosh, we can't really talk openly about this issue if that person is around. No, because under those one about disciplinary matters or performance evaluations, they have the choice to have it in open session. So you have to let them know. And if they want an open session, you can have it. So that makes me cringe too. And really, this is amazing, is I get that. The thing is, we just don't want to air our dirty laundry. That's why we want to go in executive session. And obviously, that's not a valid reason either. So all of those are things that I have gotten phone calls about often, many times, and it definitely makes me cringe. So actually, with only whatever reason for only a few people here, it's like kind of in real life, it went by faster than the other times I've done it. If you have any questions, I'm available at any time. My email, my phone number. This was recorded in case you want to share it with your full board. The other executive session was also recorded. This presentation is available online on our website, as well as those documents that I referenced. So, does anyone have any questions? anything, you know, I'll stop the recording if you want to discuss something that maybe shouldn't be recorded.
Eric, this is Debbie.
Uh-huh.
I was just going to ask, if we have an executive session that we think might be contentious, would you be available on a virtual meeting to be there with us?
Yeah, sure. Like, because it's contentious about whether or not it should be an executive session, or you would like me inside.
Or whatever.
Yeah,
Yeah.
And I'm completely available to do that. And I have actually been invited into executive sessions before, just to, you know, to answer any kind of questions. Again, I'm glad to do it. I am not legal counsel, and so I'll do my best. And I've studied it quite a bit, but you know, I always have to give that caveat that I'm not the final say. One of the nice things is that the Ethics Commission, you pay your monthly or annual fees to, and you can actually use them and actually say, you know, the board wants to talk about this, if you happen to know ahead of time, and they should be able to give you an opinion on it. So, but I am more than glad to participate, either like before the executive session or during the executive session.
I appreciate that. Thank you.
You're welcome.
All right. What is the URL of all these training resources you said is recorded?
Yeah, so down, you see Oregon.gov/ODA down on this slide right now. Oh, you're on the phone, aren't you?
I'm on the phone, yes.
Yeah, so you don't see what I'm talking about. All right, so you know, the easiest way is just Google Oregon Department of Agriculture.
Mm-hmm.
And then when you go to the ODA website, I think it's really well done. Just look for, it's kind of in the middle. There's kind of like these columns. It's really easy to navigate. You'll see Soil and Water Conservation District, kind of there in the middle, and click on that, and then you want to look for the trainings tab. So just Oregon Department of Agriculture, Google that, and navigate SWCD program, and then trainings. Super simple, at least to me, but I'd go there all the time.
Right. Okay, thank you.
You're welcome. Any other questions? Well, all right then. Thank you for participating, and if anyone has any questions anytime, give me a call. I'm glad to answer any questions, and have a good night.
Thank you.
You're welcome.